SJC-13670, Commonwealth versus Quentin Smith.
Okay, I see we have the battle of the cranes. Attorney Crane.
Morning, may it please the court. Edward Crane on behalf of Quentin Smith. Primary issue in this case is whether the Commonwealth introduced sufficient evidence that the defendant lacked a license to carry. Philip Dowd testified that he ran a search of the firearms licensing database using some spelling of the name Quentin Smith and a birthday of June 23, 2002. This search failed to produce any licensing records. However, there was insufficient evidence to link the result of this search to the defendant. There was no evidence that the defendant's birthday was June 23, 2002, nor was there evidence of how to spell the defendant's name or evidence of how Dowd spelled the name Quentin Smith when he ran the search. To establish lack of licensure through a search of the firearms licensing database, there needs to be evidence linking the result of the search to the defendant. More specifically, the Commonwealth has to establish that the biographical information, name and birth date, used to run the search matches that of the defendant.
Was it okay for it to be admissible, though? Are you saying it was admissible, that the evidence of, whatever it was admissible for the jury to look at and consider?
I think it was admissible because there wasn't a relevancy objection. I do think if there was a relevancy objection raised, that it should have been sustained without the linkage.
Well, you're downstream one domino. So you're getting at whether or not the search criteria of the person that does the search. But if I'm hearing Chief Justice Budd's concern, it's the same one I have. Go up one. Are you saying then if there was a properly foundational witness who was the sponsor of this, that they went through SJC, used the proper search parameters, and if had that witness done that when they testified, that would have been admissible non-hearsay evidence under subsection 10?
Well, I think just with respect to, I guess, admissibility in the context of relevance and admissibility in the context of hearsay and confrontation are sort of three different issues. And I think that on the admissibility aspect, it's sort of the relevance aspect, it's a question of conditional relevance. If this information about the search is testified to, and there is no linkage of it to the defendant, then it's sort of just evidence that is disconnected from the case.
That sounds like sufficiency, not relevance to me. So are you saying that the whole here is that Officer Jones could have got on the witness stand and said, I booked your client. He told me his date of birth is whatever it is. That's all they needed.
That's all they needed, and that would, if it was established what the defendant's name and birth date was, and that Dowd used that information to run the search.
And then Dowd later testifies this to the same name and date of birth.
Correct. Then it not only becomes relevant, it becomes sufficient. I think the relevance issue and the sufficiency issue are really largely the same.
Well, the relevance means, I think it's certainly admissible. It would lead to an inference, but I get you on sufficiency, which is all you need.
Thank you, Your Honor. I'll stick to what I've briefed, what I've argued, and what I think is the strongest argument, and certainly the argument that would result in the best result for my client. So I do think that setting aside, I guess, the relevancy and admissibility issue, it really is a question very similar to that we run into with a prior conviction, where it's the evidence that links this record to the defendant. And here we're talking about name and birth date, and again, there's no evidence with respect to the defendant's birth date. And then with respect to the defendant's name, there's testimony that his name is Quentin Smith. There is no testimony of how to spell his name, nor is there testimony from Dowd as to what he input when he input the name Quentin Smith into the search.
So you're saying if that's all they had, which is all they had, that wasn't enough?
Yes.
Wasn't there evidence, though, that he got the name from the DA's office?
Yes.
So why wouldn't it be a reasonable inference that he got the name spelled as the defendant spelled his name?
Well, I don't think there's any way that it's entirely speculative that the DA's office, where the DA's office would have got this name from.
You don't think maybe from the complaint?
It's possible that they did, but.
Right, we're talking about inferences here and whether they're reasonable. Why wouldn't it be a reasonable inference that the DA prosecuting the case wouldn't have given the person doing the SJC search the defendant's name as it was spelled on the complaint?
Well, even then, though, the complaint is not evidence. I think we run into a real problem, too, where when we start to say that we can trust that this information was the correct information because it came from the DA's office. I think there's a slippery slope there with respect to, extrapolate that to other trial situations where one could say, well, we think this information was accurate. No, well, how do you know that information is accurate? Because we got it from the DA's office. Every trial is based on what the DA's office believes. The DA's office believes that the defendant committed some sort of crime. The DA's office has to prove that with evidence. It can't just be proven through the mere fact that the DA believes this to be true. There needs to be some evidence here, not just that they got it from the DA's office, but where did they get it from? And just someone.
So who's going to provide that testimony, where the DA's office got the name from?
Well, I don't
You're thinking the DA has to testify?
I think it's a lot easier than trying to follow that road. In this case, if the booking officer had testified, the booking officer could have got that information into evidence, and
Because that would have come directly from the defendant?
exactly, yes.
Perhaps. I mean, in this situation, I think there was testimony that some of that stuff gets ported into the report, just if you've already been in there. But may I ask you about Judge Pellegrini, because I'm a little bit, I don't understand the nature of his error, if he made one. He accepts Dowd's testimony about the search parameters, not for its truth. He specifically says that. He's only using it for what it is that Dowd used to come back with the lack of record. But he denies the motion for required finding. So can you just tell us, if you can tell us from the record, what I couldn't get from his decision where he got for the truth, because he said, I credit Dowd's testimony, there's no reason for me to not credit, but that part of his testimony was received not for its truth. So is the error that the required finding should have been allowed on that issue because there was nothing tethering the search and the result to this particular defendant?
Yes, Your Honor. I think the required finding should have been allowed, and I think where he made a mistake is, and it's totally understandable, is sort of this burden shifting. He assumes that based on Dowd's testimony that this information that he put into the search, the biographical information and the date of birth, was the defendant's, even though there's no evidence to support that. And I totally understand where one could assume that, okay, this has got to be the defendant's information, despite there not being such evidence. And then he shifts the burden. What he says is, I didn't hear any evidence saying that it's basically undermining that this is the defendant's biographical information. But the problem is he didn't first hear any evidence that it was the defendant's biographical information. So I think it's a shifting of the burden that's the problem here.
If I may, can we move on to the Pat Frisk question? And could you possibly please, or I guess it's disputed whether there was a Pat Frisk, but could you address whether once you do not challenge the validity of the exit order, and once the exit order had been achieved and the defendant was out of the car and the firearm was in his back pocket in plain view, is there not an inevitable discovery issue here?
Well, I believe that they discovered it once they handcuff him and turn him around. So I would say, I guess at that point, yes, the Pat Frisk has already begun. Obviously, there's a huge gray area. Where does a Pat Frisk begin? Where does it end? or well, really just where does it begin, is a question here. I think there would be an inevitable discovery. I don't think it would inevitably have been discovered. If he simply exited from the vehicle, I'm not sure that they inevitably would have discovered the weapon on him. It's in his pants. So they may have discovered it, but I don't think it's inevitable that they discover it if they simply exit him from the vehicle. And I think that's where that was proper. But beyond that, that's, you know, that's where we run into the impropriety here. And I'm happy to turn to the admissibility arguments with respect to hearsay and the confrontation clause. I do think it notable that this, though it is sort of one of the secondary arguments that I raise, I do find in my review of cases involving these Guardado issues, this is an issue that's raised all the time. So the sufficiency issue comes up here and there, but I see this issue almost all the time as to whether testimony about the absence of a licensing record from the database, whether it's hearsay and whether it violates the confrontation clause. That's an issue I see all the time. So I think it is important to address it. With respect to it being hearsay, it's hearsay because everything in this database is they're what we've termed computer-stored records, in that they're human-generated records that are stored in a database. And the testimony here is about the absence of such a record in the database. And Commonwealth v. Trotto does establish that an absence of a record from a database it is still hearsay. It doesn't take that out of the realm of hearsay. And I would say that what's required here is to fall into the absence of a public record exception. The person testifying needs to know how the database was created, maintained, and accessed. I think those are the three prerequisites.
And we have that here. I mean, you might disagree with it, but one of the things about Justice Lowy's concurrence is talking about that this just has to be a preliminary determination by the trial judge if there's a voir dire of doubt, and say, okay, how do you know this thing works? What does it do? And even though there wasn't this preliminary voir dire, he testified to it. And he overruled the objection of the defense and he talked about how those records come into SJC and how we look at them and how I get them. So all of those things about having some familiarity with how SJC, all these records pour into SJC, he testified to. You may not like that, but he did testify to his familiarity with this database and how the records come into it. So why doesn't that come into subsection 10 in our common law, that now he can testify to the lack of the record?
I think he definitely testified as to how they come in. I think what's missing is the maintenance aspect.
Well, your brief suggests he'd have to be a coder or a programmer, to be, a computer person, essentially, to be able to testify.
I don't think he needs that level of expertise.
Would you
to
concede
testify
he was
to
a
this.
knowledgeable witness for confrontation clause purposes?
I'm sorry?
Would you concede he was a knowledgeable witness for confrontation clause purposes under Bull Cumming in those cases?
I would say he's knowledgeable about certain aspects of the database, but my position is essentially that he's acting as a messenger in terms of he's running the search and he's relaying what he's received from the search to the fact finder. But what's missing is his knowledge of how that database is maintained sort of on a day-to-day basis. I don't think that Dowd is someone who's completely lacking in knowledge. Certainly, he knows how the system operates, how licensing works in Massachusetts. He's certainly someone who has a basis of knowledge on those things. But what's missing is just knowledge of how the database is maintained, how it's updated. I think that's critically important. And that doesn't mean that I honestly think if he had provided more testimony, he may be someone.
He testified to how it's how data is inputted, correct? Where
Yes.
where it comes from.
And to the extent that you have an issue with that, isn't that what the whole point of the cross-examination is? To argue to the jury that you can't trust what he's saying because he doesn't know if it hasn't been updated and all these other things. But I do want to get to one thing in particular. You're saying that this is the problem with getting somebody in for SJC. We're going to have this case on right after, where they say, oh, no, don't do this. You could just bring somebody in from CJS. So what is the defense perspective here about how, it seems like that on the defense side, that folks are talking out of both sides of their mouths when it comes to this?
I understand that because I do think that there have been arguments raised that, frankly, the argument raised by trial counsel in this case was essentially that the only person that could potentially testify about this is a licensing authority, someone from a municipality. I'm not going to go that far. I think that what is adequate is, and it doesn't have to be the keeper of the records or a custodian of the records of CJS. It can be one of these CJS employees. They just have to lay the foundation first, that they know how, like Dowd did, testifies all about how the records come into the database, how the records are created. He has to testify about how the search works. That's sort of the latter half of it. But then it's that middle third that's missing. You have to have someone who testifies about how the records are maintained. Once they come in, what happens to them between, say, creation and expiration. That's what's missing. And
Can you just walk me through what you think that would entail?
I think that would entail someone describing what happens to a record once it's created. Does it stay there indefinitely? How is a record updated once someone renews or doesn't renew?
Suspended, expired?
Yes.
Those sort of testimonial aspects of beyond creation and access. What happens to it in the middle?
Yes, exactly.
I thought you testified to that. I thought you testified that you get entered and then you're either revoked, suspended, or the other category, or expires.
He did testify about those different statuses, but he didn't testify about how those statuses are updated. How does one go from active to revoked? I mean, it clearly happens, but what's the process?
An unlicensed authority, you'd have to call every police department where the person's ever lived past 18.
Yes, Your Honor.
I'm sorry, past 21.
Yes, Your Honor, and certainly that's an impractical result, and I don't think it's required by the law. I think what's required is just someone who can satisfy those three prerequisites, knows how it's created, knows how it's maintained, and knows how it's accessed.
What's your best case for the proposition that a database that's maintained, a database that aggregates local or state governmental records is testimonial?
I would say Commonwealth v. Trotto.
That's your best case?
I think that's the best case. The court does say that those are.
Those weren't, well, I won't argue with you.
Okay.
Is it testimony? The database is it testimonial, or is it the search that was done for the purposes of presenting lack of license, an element of the crime? That's what's testimonial, right?
Yes.
And here you had access to Dowd, witness Dowd, who actually did the search. So why does it present a testimonial problem? A confrontation clause problem. You were able to confront the witness who did the search for purposes of the trial.
I think that there's a testimonial aspect in Dowd's testimony that he ran the search, but then there's also a testimonial aspect of the records themselves. Well, I guess no, that's not.
No.
No, that's not accurate.
No.
It's really Dowd's testimony that.
But he was there. He was presented at trial, so you were able to confront him.
And I guess the issue with the confrontation clause issue would be that he can't be cross-examined about
Maintenance.
the maintenance aspect of it. And I guess where the problem is, the hypothetical is.
Well, he can be cross-examined, he just doesn't know.
Doesn't know, and if you put
Well,
someone on the stand
maybe.
who's even less knowledgeable than Dowd, if they were, someone, you put a teenager on the stand, and they ran the search, they're probably capable of running the search, and then saying, well, this person, they ran the search, so you can cross-examine them, but they can just say, they have no, I don't know anything about how this database is maintained. And so it's not really, the confrontation right is sort of void in that situation.
Okay. Thank you.
Thank you, Your Honors.
Attorney Crane.
Good morning, and may it please the court, Jesse Crane for the Commonwealth. I'll start with the first part of the sufficiency claim in terms of whether the date of birth and the name needed to come in.
How do you get past the DNA CODIS case, Sullivan?
Sullivan, I think it's a reasonable inference to draw from the testimony that came in at trial that this came in through the booking process. None of the officers who testified were involved in the booking process, but there was some discussion during Officer Mazzoni's testimony as to what kind of information is gathered in the booking process.
All of it which was objected to and sustained. Judge Pellegrini was very clear about that. And the only effort that the Commonwealth made was to say, I can get a booking officer here at 3:30, but Judge Pellegrini didn't let him do that. So how do you, going back to Justice Gaziano's question, how do you get past that? Because you also have to grapple with, Judge Pellegrini says explicitly, I'm not accepting the search parameters for its truth. So where do you get the evidence tethering what Dowd did to that defendant?
I mean, I think if you, looking at it from the other end, working backward from Dowd's testimony, you get it in through the fact that he got that information from the DA's office. I think it's...
But that presents a problem with which your opposing counsel has already articulated. Can you address that?
Absolutely.
Why are we going to just believe that the DA has the accurate spelling and date of birth?
I don't think you have to. I think
But don't you have to for the sufficiency of the evidence? I mean, that's what you're suggesting, that, oh, the DA must have it right because I guess they're the DA?
Well, I think the issue with Dowd's testimony really is just whether he had sufficiently reliable information to run the BOP-FI query. And I think it's a reasonable inference that getting that information from the DA's office was at least reliable enough to be admissible and sufficient.
Well, he could always testify to what he did, right? He did that. The question is whether it's sufficient to link that information to the defendant who's on trial. That's the piece that I think we're all struggling with.
And I think there are a couple factors about the BOP-FI search itself that perhaps ameliorate some of these concerns. There was the testimony about the SoundX nature of the search.
Right, but it all fundamentally requires the spelling of the defendant's name to be correct, either the first or last name, and also that the date of birth be correct. And there was no evidence other than the suggestion that the DA must have been accurate when they gave these search parameters to Dowd, that those in fact were accurate. I mean, I understand the search and how it works, but if bad data in, bad data out.
I think for the date of birth, I have a little bit of a harder time.
Well, isn't that necessary? I mean, given that the last name is Smith?
Right. I think for the name, the fact that Officer Mazzoni identifies the defendant as Quentin Smith and says he testifies to the fact that he knows the defendant from prior interactions. I think that helps us
Does
with
he
the name.
testify that he gave Dowd that name spelling?
Mazzoni does not.
Okay.
No.
So he just says the name, he doesn't spell it
He
for the
doesn't.
transcriber? No.
He does not.
Okay,
No.
so we don't know how he's spelling Quentin Smith.
We do not know.
Okay.
That's correct.
Could you turn to the question of what inference can be drawn from the fact, even if we were to assume that the search parameters were correct, but the fact that the search resulted in no records, how are we supposed to know, or anyone to reasonably infer, that that means that at some earlier point in time, or the person has never had a license, as opposed to that search simply means that at the moment in time when the search was conducted, he didn't have a license?
Right, so there was testimony from Dowd that the Firearms Record Bureau is the repository of all licensing records related to firearms for the Commonwealth. And in the beginning of his cross-examination, Dowd also testified that if someone had a license at some point, it would appear in the BOPFI search. And he further testifies that you would see the status as either active, suspended, expired, or revoked.
For how long?
He does not say, but I think it is a reasonable inference because of the nature of the statuses.
Yeah, what's the reasonable inference?
I think because he testifies that a status could be expired or revoked, it's a reasonable inference that it persists
For how long?
for indefinitely.
Really?
Yes.
When was CJIS created?
I believe CJIS was created about 40 years ago. I'm not sure. It's not in the trial record, so
But what is in the trial record is Dowd testifies that he was a state trooper for 28 years, and he used it throughout his career.
That's correct. Yes, he was consistently running CJIS queries going back for his entire career. And I do just want to address the connection between the subsequent OUI records and the BOPFI query. I don't think that's quite a good analogy in this case, because in the instance of the subsequent OUI, the concern is really that defendant John Doe is not the same person as John Doe named in the prior conviction. With the BOPFI query, it's not a record in and of itself, and it also generates results that could be more inclusive than what would come in, than what could be connected to the.
Or less inclusive, right? I just don't see why the OUI analogy isn't a good one.
I think the date of birth does limit it, but again, the Soundex query, the Soundex nature of the query could potentially pull in more names into the search results than would necessarily include the defendant.
Wouldn't the difference be in an OUI second subsequent, the government has to prove beyond a reasonable doubt that element? Here, this is an adjudicatory fact towards proving he's unlicensed, correct?
Yes, that is correct.
Right, but still, you have to get past sufficiency, even if it is an adjudicatory fact.
Yes, I agree with that.
Right.
If there are no further questions on the sufficiency portion, I will turn to the confrontation issue. I think when you parse out what the statements are here, there isn't really a confrontation issue. So the testimonial statement here was no records found. That was a function of Phil Dowd running the BOPFI query, and he was available to testify. He could testify to what he inputted. He was a knowledgeable witness. He extensively testified as.
What was his testimony as to the maintenance of the database?
He testified that the licensing authorities and the Firearms Record Bureau are the entities that can revoke the licenses, and that would be reflected in Merck's based on his other the testimony that the status is updated in Merck's once that event occurs.
But there's no testimony as to how long records are maintained, how the entities responsible for updating actually update the record. Isn't that problematic from both the hearsay and the confrontation clause problem?
I think there's a fair inference from the fact that he so extensively describes the creation of the record that the licensing authority also would probably go through a similar process, entering the fact that they've revoked the license in Merck's.
As I understand, and you correct me if I'm wrong, because I'm not an expert in this, as I understand the creation testimony, it was that the local authority takes down the information, it goes to some other entity for a background check, and then it gets activated. Is that what you're suggesting happens, that I should infer from the evidence happens when a record needs to be updated, that the local authority does some sort of updating, it goes to another entity for confirmation of some sort, and then it gets updated?
I think the way the testimony came in, as far as revocation goes, so for the updating portion, it was that the local authority or the Firearms Record Bureau directly can revoke the license.
And that's in the transcript?
I
No, I mean, yes, they can revoke the license, but how they update the record once they do that? Once they revoke it, once they suspend it, once it's expired?
I don't believe there's direct testimony to that effect. I do think it's a fair inference because Merck's does reflect those events. There was testimony directly to the fact that the status does change in Merck's. And so if a licensing authority is the entity that's revoking it, the fact that that appears in Merck's, I think, suggests that the licensing authority has done something in Merck's to do that.
How hard would it be just to ask Dowd?
I think the defendant could have done that.
Right, no, but it's the Commonwealth's burden of proof, as we all know.
Yes. I think we could have asked that, but I think the fact that he did testify to the fact that these records are updated in Merck's is sufficient, at least to establish that he understands how the records were maintained. And the fact that they're kept in Merck's, they're updated in Merck's.
Indefinitely.
Yes.
Okay, thank you.
Can I just go back to the sufficiency? I might have missed how you explained how this document, assuming it's admissible, is enough to show that it was this defendant. I understand that it goes towards proving that it was this defendant, but I don't see, help me understand how it's sufficient to find him guilty.
I think it's a two-part. There's the information that Dowd received from the DA's office in terms of this is the defendant that was arrested by Officer Mazzoni.
And that's taking for granted that the name was spelled correctly and the date of birth was given, all of that.
I think that can only come in to prove what Dowd entered.
Right, well,
But I think the second part of it is the fact that Dowd does a search of the entire licensure database. So the entire universe of records is examined in that BOP-FI query, and the fact that there is no record found based on that query provides an adequate basis to infer that the defendant never received
and
a
he
license.
used all the different ways to spell Quentin?
There was not testimony to that. He said, I searched for Quentin Smith with a date of birth of June 23rd, 2002.
Okay.
If I could just address the testimonial piece of the confrontation portion, I would just note that the underlying records are not testimonial. Those are official or public records that are issued by licensing authorities pursuant to a statutory authority to give someone who's eligible an LTC or an FTC or an FID. The database itself is also not testimonial. Merck's and SJC are maintained, again, according to a statutory responsibility of the Firearms Record Bureau to aggregate.
But Dowd's testimony is testimonial, right? His search was
Yes.
for, okay, so let's
Yes.
focus on that.
Dowd's testimony is testimonial, but he was present to be cross-examined.
And your brother, opposing counsel, said that because he didn't know how the database was maintained, it was not good enough. It was like having a teenager just run the search, he was saying.
I think that's a little bit of an unfair comparison. I think
Right, so tell me why.
I think he was very knowledgeable about how records were created. He testified extensively to that. He
Right, but
testified
focusing
about,
on maintained. Sorry, I mean, just your time is running short. So,
Sure, of
So
course.
focusing on his presence at trial to testify as to what he did, in light of the fact that he didn't testify as to how the data was maintained or were maintained, why isn't that a confrontation clause problem?
well, I think his testimony did suggest that he knew how it was maintained. It certainly was not the most exhaustively developed portion of his testimony, but I know I keep repeating this, but he did know that the status of the license would change. He did know that the Firearms Records Bureau or the licensing authority could revoke it. I think the fact that it wasn't explored further doesn't necessarily undermine the fact that the defendant's doesn't suggest that the defendant couldn't have cross-examined him further. And I think that did satisfy sort of the threshold question of, was this witness knowledgeable enough to be cross-examined on that particular piece of the database?
Chief, could I ask one question about? Go back to the suppression question. I'm trying to figure out how putting this defendant in custody bears on the issue of inevitable discovery. Because your brother says, if he were just ordered out of the car and not placed in the custody, that's the part that brings to the attention of the officers what might be in his sweatpants shorts pocket. How does that figure into the argument that you're saying it wasn't even a pat frisk, which I don't necessarily disagree with you, but that part about just get out of the car, and rather than get out of the car and turn around and put your hands behind your back, and that's when they see it.
I think it would be more problematic for me if the gun were all the way in his pocket, but here we have the butt of the gun sticking out of his pocket in plain view. I mean, I understand that the order of events was that he was cuffed and turned around and that's how it was discovered, but I guess I would suggest that the butt of a gun hanging out of a pocket is in pretty plain view. And that would lead inevitably to its discovery.